Hello, good morning, guys. Good morning. I'm just here to talk to you today about the process of petitioning for your family members. So it's known as petition for alien relative or the form I-130 filling. So we're going to do a quick one on the difference between the various types of processing. So to start, there are usually two categories in which people are grouped. If you're a U.S. citizen or a lawful permanent resident who's a green card holder, there are different types of people that these two people may be able to apply for. So as a U.S. citizen, you're able to apply for more people than a green card holder or a lawful permanent resident is able to apply for. A U.S. citizen may be able to apply for their immediate families. So the immediate family category is actually the top of the rank. And top of the rank means that these people's cases are processed very fast and they do not need to wait until a visa is available. Usually there's a number of visas that are available each year, and depending on the rank in which you fall, a visa may be available to you or not. Okay, so when you're a U.S. citizen, you are top of the rank and you can apply for your immediate family. Immediate family means that the person is either your spouse, your child, and a child is defined as a son or a daughter who's under 21 years old and who's unmarried, or your parent. And so parents of U.S. citizens also have priority. So these are the three immediate relative categories. Then we come down to what is known as the family preference immigrant. So the family preference immigrant, there are about 1, 2, 3, 4, 5. Yes, there are 5 ranks of that. And the first preference, when we say the first preference, as I said, depending on the number of visas available, let's say if there are 100,000 visas available for the year, they will go according to the rank. So they'll evaluate the first preference first and then give them visas before they go to the second preference and the third and the fourth. Okay, so with the first preference category is usually for unmarried sons and daughters of U.S. citizens. Now, note the difference here. There's a difference between a child of a U.S. citizen and the son or a daughter of a U.S. citizen. A son or daughter of a U.S. citizen means that the person is above the age of 21, but the child is under 21 and unmarried. And so if you're above 21 years old, you're a son or daughter. If you are under 21, you're a child. So that's the first preference. The unmarried sons and daughters of U.S. citizens, you have to be unmarried. And the person petitioning for you as a beneficiary has to be a U.S. citizen. The second preference is the spouse and child of lawful permanent residents. So these people are given priority secondly. These are the wives or the husbands and the children of U.S. citizens. And children again means unmarried and under the age of 21 years old. So that second preference is known as the F2A. The other preference is this. There's a second preference, which is the F2B. So there are two categories of second preference. The other second preference is unmarried sons and daughters of lawful permanent residents. Okay, so you see the difference. The first category is unmarried children. The second preference is unmarried sons and daughters of lawful permanent residents. And this is for people who are older than 21 years old, but are still the offsprings of green card holders. Once they are unmarried, they are the second preference, the F2B. Then the third preference is the married sons and daughters of U.S. citizens. So if you have a family member who's a U.S. citizen and you are their son or their daughter and you are married, you are eligible to be given to be able to apply for and receive the benefits of a green card. The fourth preference is the brothers and sisters of U.S. citizens. So that's the siblings of U.S. citizens, and the U.S. citizen has to be 21 and above to be able to apply for them. Okay, so that's the difference. You have to note the difference between these types of categorizations, and all of this simply means that if you're a U.S. citizen, you have a broader leeway. You can apply for your parents, you can apply for your siblings, you can apply for all your children. It doesn't matter if they are married or unmarried. The difference will only come in terms of the preference when the visas are being granted. And this preference categories is relevant depending on where the beneficiaries are located. So if these family members are here in the US, they are on US soil, usually we file an adjustment of status. That's the so we do the petition for the alien relative, that's the I-130, and then we add the adjustment of status, which is the I-485 together. Okay, with this type, we do it for the immediate relatives because they don't have to wait until a visa is available or not. However, we do the one step, we do the I-130, and then we do the consular processing if the beneficiaries of these petitions are abroad. Okay, so for example, if Mary is a U.S. citizen and she lives in, let's say, New York, and she has her spouse who is in some part of Africa. Let's say her spouse is in West Africa, Ghana. Because her spouse is in West Africa, Ghana, West Africa, we would have to do the I-130, the petition first. And then with this petition, we will be seeking to establish the relationship, the spousal relationship between them. And then we can do consular processing because the beneficiary of this petition is abroad. Okay, and so when you file the I-130 just seeks to establish the relationship. That is the first step. You need to establish the relationship, the basis of the relationship between the petitioner and the beneficiary of what you're filing. And so in our case, where Mary is going to establish that maybe Joseph is her husband who's in Ghana, West Africa, that's her spouse, she needs to be able to provide a marriage certificate that establishes that there's a relationship. Okay, that proves that there's a relationship, there's a marital relationship between the two of them. So that's an example. If Mary is here in the United States and she has a child who is, let's say, a 15-year-old child, of course, unmarried, what Mary can do is to do the I-130 and then file the I-485. We can do a concurrent filing because the child does not have to wait until the child is an immediate relative, and so once we do the two together, what we will be establishing with the I-130 is we need to show proof of the birth certificate that lists Mary as the mother and the child as the beneficiary child as the child of Mary. So once the I-130 establishes the relationship, then once it's approved, we can do the adjustment of status because Mary's child is right here in the US, so we can do the adjustment of status. But you can decide to file the two together concurrently, or you can do a two-step. And so I hope this is helpful for various people who are trying to. It can get really technical, so you know what, you don't have to go through all of this, you don't need to understand all of this, you just need to hand it over to me. I help immigrants all around the US to regularize their stay, or to help family members also obtain green cards right here in the US. My name is Akua. I'm a US licensed attorney, and you can call me on 240-801-7288 or visit my website akpokulaw.com. I can't wait to speak with you. Thank you. Bye.